Hello, good evening. Welcome, everyone. Please be seated. Good evening, Inglewood. Thank you so much for joining the Inglewood Municipal Court for our inaugural State of the Court presentation. It really does warm my heart to see so many community members gathered to learn about our court. And I say our court very intentionally tonight, as it truly is the people's court. Judge Wapner may give me some flack about that, so how about the community court? I hope that many of you truly feel that way about our court, and I hope that after tonight's presentation, more of you will feel that way. We've historically enjoyed a court system here in Inglewood that we can all be very proud of. Tonight represents another step towards a vision of a more transparent and more community-based approach to the shared local issues, including our third branch of our city government, our court, that is so critical to our local society. I'm Joe Jefferson. I'm our presiding municipal judge. I love our community. I'm proud to serve and proud to call Inglewood home. I want to thank all of you, the community in the room, for setting aside time to become more engaged, educated, empowered residents, judges, attorneys, service providers, and leaders. It's a privilege to address this group tonight and get an opportunity to provide insights into the court's achievements and challenges, specifically over the last few years, where we find ourselves today, and our vision for the future. I will try to provide an overview of the organizational structure of our city government as it relates to our local criminal justice system, as well as an overview of our court operations and recent changes, including highlights of our new community justice services, as well as our newer court navigator and restorative justice programs. Our elected judge has the unique challenge of being a full-time judge, as well as overseeing a major branch of our local government. It's been a dynamic and challenging time for all of us over the recent years. Courts are no exception, so I think it's important to keep the community informed about recent changes and provide more public information about what we do and why. I want to introduce everyone to our wonderful court administrator, Kenitha Julian. KJ's helped make everything possible tonight. She is our fearless administrative leader who keeps us all on track around here. She's a recovering attorney with a wealth of knowledge and experience, and I couldn't do my job without her, so thank you, KJ.
Thank you.
I also want to introduce some of our associate judges who serve our community by being recommended by our presiding judge and then ultimately appointed by our city council to serve 4-year terms. The court has made at least 2 public calls for applications in the last 5 years. We may do so again in the next year, as the recent appointment of Ben Figa by our governor to our district court, as well as retirement of some of our recent judges, has left us a little bit shorthanded. In attendance tonight, currently serving terms, we have Judge Dave Spracacci, Judge Tamara Palmer, Judge Jonathan Lucero, and last but not least, Judge Claire Lee Carlton. Our former presiding judge, Vince Atencio, also serves an associate here to this day. Unfortunately, he couldn't be with us tonight. Please keep in mind, all of these folks are both Inglewood residents and local practicing attorneys, so I really want to thank them for all of their years of service and dedication to our community. I also want to thank our other elected officials and city officials tonight for attending. I saw Mayor Pro Tem and Council Member at Large Steve Ward here tonight. Steve, thank you for being here. I also see our city manager, Sean Lewis, here tonight. I appreciate Sean being here tonight. I see our former mayor and current council member, Jim Woodward, out there. I also see a bunch of directors, including our chief of police, Sam Watson. Thank you, Chief, for being here. Also, we have Council Member at Large, Rita Russell. Thank you, Rita, last but not least. Appreciate you being here, as always. Thank you all for being here tonight, for your service to the community. I know that as public servants, sometimes the job can be a bit thankless, so I want to thank you all and know that you're appreciated. I genuinely admire all of you for setting aside time tonight to learn about a very important topic in our community. Our court was established by charter in 1959. Hopefully everyone is aware of the separation of powers doctrine as modeled by the U.S. and Colorado constitutions that creates a separation of powers and checks and balances by separating the 3 branches of government. Our founders in Inglewood were wise to use a separation of powers model in our charter. This means, for example, that local police matters are executive and city policy matters are legislative. Municipal court matters, however, are judicial and fall under the authority of our elected judge. Our unique local government structure has many benefits, including true separation of powers that I believe increases public trust in our local judiciary. Our court sits between the city government, who represents the people in our cases, and a private individual to provide a fair public process to efficiently and effectively resolve the conflict. Please understand that our court only hears cases that are initiated by a filing from the city. Sometimes arrest documents, but usually a ticket issued by a police or code officer at the city's discretion against a private individual that alleges a violation of our local municipal law. We are a criminal court, although we do hear decriminalized traffic and parking offenses too. In each of our cases, the city gets to decide who and what to charge a person with, and the city is represented in every case by an attorney, our city prosecutor. Our court has exclusive jurisdiction over matters that are alleged violations of our laws only, and what some might think of as concurrent jurisdiction with state law and the state court system. However, these are not technically concurrent, as the issues stem from different bodies of law: municipal ordinance violations filed here versus state statute violations filed in county or district courts. The court does not get to choose what cases we hear. Our court simply hears the cases that the city has filed. Our maximum jail sentence is 364 days, and our maximum fine is $2,650. That means that all cases in which the law supports a larger potential penalty must be filed in our state court system under state law. Municipal offenses are their own category under the law and are not technically felonies, misdemeanors, nor petty offenses. However, our cases would be the state equivalent of misdemeanors on the high end, down to offenses with no state equivalent in the state system. There are many benefits to the community by proceeding in a municipal court rather than the state system, including our ability to reach much faster disposition in cases, convenience for the community, a deeper understanding of local issues, stakeholders, and ultimately the impacts our cases have on people in our community. Therefore, our community members are exponentially more likely to have interactions with a municipal court than any other type of court. So we have a unique opportunity here in Inglewood to make a lasting impression on our community, to reduce recidivism, to increase public safety for all, and to ensure trust in our judicial system. The good news is that criminal justice is a team sport, and all of us in this room have unique roles to share that collective responsibility of securing liberty and justice for all here in Inglewood. As Martin Luther King famously said, "Injustice anywhere is a threat to justice everywhere." The rule of law on which our nation and city are founded is sustained only by society's collective belief in it and our collective responsibility to uphold it. Our court's simple mission is to ensure justice with dignity for all. Our court must ensure a fair and impartial system to resolve disputes with our local government. This process ensures accountability for all parties, including the court itself. We must give respect to all who appear. We must understand that trust is earned. We welcome all who appear. As many have said, our community as a whole has been recently reminded that confidence in our justice system is fragile and not universal and cannot be taken for granted. The court must protect the rights of all people, not just some favorites. In my humble opinion, the way in which we do our job in this courthouse helps inform the people's opinions of our local government as a whole. If we're fair in our administration of justice, the public will feel more respected and protected, more like they are treated fairly, and more satisfied that they've had their opportunity to be heard. One of the court's other primary functions is to deter and punish crimes when appropriate. This helps create, define, and enforce social norms through a legal public process. Jail is sometimes an appropriate sanction in our cases for the dangerous and egregious situations after considering alternatives. However, our court also has rehabilitative and restorative functions. On an individual level, this is accomplished with interventions for individuals who find themselves on self-destructive, violent, or harmful paths. Our goal is not just to punish offenses, but also to refocus an individual on education, personal responsibility, and ultimately restoration of the community. Our court has a shared mission with many regional agencies and have recently cultivated great partnerships for services. This reflects a more community-based approach that create win-win situations for the community. These partnerships help remove the financial hurdles to education, mental health counseling, substance abuse treatment, and other services needed for successful rehabilitation. This is all in an effort to ultimately protect public safety for everyone in our community. We impact public safety by trying to impact people's lives and injecting what I call right-sized personal responsibility, right-sized both to the individual and the offense. This requires time to try to understand the underlying issues with a person's behavior and the incident to try to problem solve on behalf of the community. As part of our mission, we now provide resource guides available to all defendants and the public, including one specific for U.S. military veterans and another for juveniles that connect them with local agencies and provide everything from food, clothing, and medical services to emergency housing. Our court is also dedicated to improving perceived fairness and efficiency within our legal system. We've embraced many newly expanded alternative sentencing for those that qualify, including work release, in-home detention, special jail treatment, and educational programs, in addition to our local rehabilitative and restorative practices. We've also implemented court date reminders by phone and hope to expand to email or text soon. Our focus on fairness and efficiency has also led to recent improvements in access to justice. The court has a new standing court docket time where individuals without the means to post bond can go before the judge for bond reconsideration. This process allows the defendant to proactively address their issue, usually without being arrested, and is an efficient use of our system resources to resolve their matter in a timely manner. Moving on to the community justice. Our great partnerships and community work have provided really great, meaningful community service opportunities that provide defendants both an opportunity to right a wrong in our community through public service, as well as an opportunity to get services and resources themselves, all at no cost to them or the court. These efforts help ensure personal responsibility is ultimately achieved, rather than simply a waiver or reduction at sentencing based on inability to pay. This chart breaks down the cases we've handled over the last 5 years. Criminal contains a mix of criminal charges, including crimes like crimes against a person, like assault or harassment, crimes against public peace, like disorderly conduct or false reports, property crimes, like shoplifting and trespassing, business licensing and tax offenses, animal offenses like dangerous behavior or running at large, offenses involving minors, like wrongs to children or charges against juveniles, real property code violations like snow removal or zoning, and offenses like possession of drug paraphernalia or open liquor, and many others. So as you can see, quite the variety of issues being resolved by our court. The chart also shows domestic violence offenses separately, and these are the most serious cases we handle for many reasons, including the potential for future violence, formal protection orders, and firearm relinquishment orders. Keep in mind, we're only one court where the police may file the domestic violence cases into, so please keep in mind that this is only a portion of the story of domestic violence in Inglewood. The future of municipal domestic violence jurisdiction is pending a policy decision by City Council with recent state legislation that we're going to discuss later this evening. The chart also shows the number of traffic offenses versus less serious decriminalized traffic infractions and parking cases. The chart shows that we are a busy court, and although we handled less than 5,000 city filings again in 2022, that only represents a decrease in filings year over year of about 13% when compared to 2021. However, this also reflects a much more substantial decrease in criminal filings in our court of approximately 35% year over year and nearly 67% since 2019. Total traffic enforcement, excluding parking, is down nearly 46% year over year and nearly 76% since 2020. However, as of the midpoint of this year in 2023, that's not shown in this chart, we're only down about 8% total year over year, and criminal filings are up about 14%. Our court is also seeing an increase in arrest activity here in Inglewood in just the last few months and last few weeks. Again, keep in mind, we're not the full picture on enforcement, as most crimes that occur in our community are filed in county or district court currently. Let's take a look at how that information compares to the recently reported crime trend data from Inglewood Police. What they call Group A is all contained in what we at court call criminal, and our bucket is larger, as I just described. We see a slight decrease in 2022 from 2021 with some of the good work done in the last year and a half. However, 2021 represented a much larger increase year over year compared to 2020. This tracks with my view that compliance with the law is generally down since COVID began. Keep in mind there are several factors to consider when looking at enforcement, including staffing levels, severity of calls for service in our community that have only been increasing in the last few years. It's also worth noting that in 2019, the last full year before COVID, over half of the Group A offenses were filed in our court. And in 2022, less than 14% were filed with our court. It's my understanding from my conversations with our police department that traffic enforcement has declined due to staffing as well as lower priority, but we can, as a community, expect increases in the future as that resolves, but we may never get back to pre-pandemic numbers anytime soon. Despite the drop in the volume of the cases, our court remains very busy with all the changes in the last few years brought on by the COVID pandemic, substantial legislative changes impacting criminal enforcement, and municipal court operations. What can account for the substantial fluctuations in our system in just a few short years? The short answer is the unprecedented and delayed impacts of the COVID pandemic, as well as its longer-term consequences, coupled with recent legislative reforms that have stressed the system. Most of the question is better left to the executive branch on matters of enforcement that they can better and speak more directly to. However, there are many factors that impact our local criminal justice system that I hope to explore with you tonight from the court's perspective, as these numbers have substantial impact on our community and our court. Please keep in mind that all organizations, including courts, government, and law enforcement, have been stressed in the last few years. The COVID pandemic brought our society to a screeching halt. This includes the criminal justice system. Most of these impacts began with the closing of the jails almost immediately upon COVID hitting in March of 2020. And that continued for an extended time for municipal offenses. Slowly, the sheriffs in each county gave guidance on admission standards to the jail, and here in Arapahoe was mostly based on the amount of the bail that slowly reduced over time, allowing more and more of our cases. These restrictions essentially closed our local jail for our cases for over 2 years, and that had a substantial impact on our ability to resolve cases in a timely manner and likely impacted police department's decision on where to file cases. This has resulted in a substantial backlog of cases, particularly for those that did not want to appear to resolve their case. However, as of over 1 year ago, the jail is now accepting all of our cases, and we have made substantial progress in our backlog and hope to renormalize next year. However, a major issue of in-custody transportation remains unresolved in our system. Prior to COVID, we relied on the metro area sheriffs to transport a person picked up, for example, in Denver on our municipal warrant and bus them to Arapahoe County to be seen by our court within 48 hours as required by law. However, now there is no general transport provided for people with only municipal holds, and they were released on a personal recognizance bond by that sheriff, which can lead to a revolving door and records management issues. The ultimate solution is yet to be determined, as we've seen some improvements in the system of cooperation from a lot of the metro area sheriffs, but we may need to consider having our police provide more transport services from other county jails to keep a few cases of legitimate public safety in custody, or, knowing how busy our PD is, we may need to consider a court-martial function to handle transports and maybe be combined with some other court functions, for example, like security of the court. The positive side of COVID is that we have developed a lot of new solutions using new technologies for our newer problems. And these have resulted in tools that will stay in our toolbox forever. We've substantially expanded our ability to proceed in our cases virtually. This has provided some efficiencies and higher service levels to the public. Some cases are granted the ability to appear virtually by our court, although we generally prefer our cases in person, particularly for criminal offenses, but we're now seeing people all over the state, both in and out of custody due to this technology. Other challenges include unfunded state legislative mandates. I'll begin with debtor prison reform, which was initiated or clarified through House Bill 161311. This stopped the debtor prison process of jailing for inability to pay for fines and costs. Instead, the law requires a separate contempt action for failure to pay the fine and a separate finding that the court fees were not an undue hardship and that the defendant was intentionally refusing to pay when adequate resources existed. That has made collections extremely much more difficult, and beginning here in about 2017. However, the fiscal impact of that was not really felt for some years, given case volume increases, particularly with traffic filings over those years. Next, mandatory in-custody court-appointed counsel initiated through House Bill 16-1309. This was delayed until July of 2018, and basically mandates that we must essentially provide a lawyer to all people we see in custody. This is a substantial mandate that is only partially funded, but does improve people's understanding of their cases and does provide some court efficiencies by having a lawyer to work with in our court for our in-custody cases. Court-appointed counsel services are now contracted through the Office of Alternative Defense Counsel for review and approval and ongoing observation to ensure competency and independent counsel for our defendants. We're now providing more court-appointed attorney services than ever before to help ensure better understanding for all who qualify. We've also seen the implementation of mandatory personal recognizance bonds for property offenses under $50 or for offenses that are lower than a misdemeanor. Petty offense as defined by the state or below, including offenses in which there's no state equivalent charge. These reforms have had a major impact as it took discretion away from our judge to hold a person on a municipal charge if it's a property offense of less than $50 or lower than a misdemeanor. This means that if someone is given a ticket for a theft of $49.99 and does not come to court, the judge can issue a bench warrant and set a cash bail to take them into custody if appropriate. However, if the defendant cannot post that bond amount, when the defendant appears in front of the judge within 48 hours as mandated by law, the judge must release them, regardless of how many times they failed to appear or their criminal history, so they could have 100 cases and still get PR'd on all of those matters if they met those requirements. So this has also created a bit of a revolving door issue in some of our cases. Next, we have the end of outstanding judgment warrants initiated through House Bill 21-1314 that was initiated as of January 1st of 2022. This mandated that our court can no longer effectuate a suspension of a person's driver's license for failure to pay or comply with a traffic case here in Inglewood. So for minor traffic infractions, the only real motivation to comply is really to reduce points and perhaps to avoid collections. However, some people are not motivated by these factors. Additionally, although the court can still issue a bench warrant for failure to appear for more serious traffic offenses, after that person takes a plea deal, there's no great motivation to pay your ticket, as the case cannot default back to the original charge like a traffic infraction can, so collections is really the only enforcement mechanism post-disposition on a traffic offense. Next, we have the so-called clean slate bill effectuated by Senate Bill 22099. This went into effect as of January 1 of this year and requires records not resulting in a conviction to be automatically sealed. This is a very common outcome for our court due to the outright dismissals as well as plea agreements offered by the prosecutor that end in dismissal, like a deferred judgment or a deferred sentence or deferred prosecution. This requires significant staff time to comply with and is an unfunded mandate of the state. Domestic violence cases are not currently eligible until after a hearing. Next, we have 48-hour bond reform initiated by House Bill 21-1280. This has required us to have virtual hearings on Sunday afternoons as of January 1 of this year, and this also had no funding from the state. This strains staff time to meet new timelines, and if they're not seen by us, they will be released on personal recognizance bond by the sheriff. We have substantial public safety issues in our system that are not mandatory personal recognizance, like domestic violence cases and assault cases, so we must maintain the ability to comply with Sunday hearings to ensure public safety here in Inglewood. Public trust has also become an important issue, probably the paramount issue for courts in recent times. Trust that we're truly independent and fair and not in cahoots with the prosecutor or the defendant. Trust that we are a legitimate source of authority. Trust that we understand implicit bias in human behavior. Trust that we value diversity of our bench and try to reflect the community we serve. Trust that we understand the value of a community-based approach to local problem solving. Trust that we protect public safety. These are difficult issues that require a nuanced and knowledgeable approach to each of these cases that comes before us. Public trust is paramount to public safety. Public trust impacts not only people's compliance with court orders, but also general compliance with the law. I believe we've done an excellent job of ensuring public trust in our court through an unprecedented time. Like all organizations, we've been plagued by staff turnover due to the great resignation and the great reshuffling brought on by COVID. It's really left us all with a loss of institutional knowledge, created training gaps in all of our operations that we're all struggling to fill. However, I believe our court has managed this better than most, and that the worst of the pain is behind us. We have the leadership in place to build back our system using new tools to be stronger and more efficient than ever before, and that is currently a work in progress. Technology continues to be a source of both innovation and increased service levels, but also a source of frustration and requires expertise that is not traditionally required by court staff. We continue to struggle with the full implementation of our newer case management software. This is exemplified by the continued lack of payment portal for the public to be able to pay online, as well as the ability to view their upcoming court date. We've asked city management, IT, as well as the city attorney's office for more support, as well as the vendor themselves, with only limited success. This creates a strain on our staff. They need to collect on every case manually. They need to make manual adjustments in the software to get the correct total in the cases, and that is frustrating. Our taxpayers have not gotten the benefit of the bargain from both a public service level as well as taxpayer efficiency standpoint. Statewide criminal reporting and warrant and bond management between jurisdictions has also been problematic for us. There have been discussions on the statewide level for a better system for municipal offense reporting, because if defendant is not arrested and booked into jail nor fingerprinted by our police, then there's no way for outside jurisdictions to see these convictions without contacting us. Further, how some sheriffs are handling our warrants has led to some confusion during COVID, but this issue does seem to be resolving as sheriffs statewide have implemented better policies and procedures. And I hope by the end of the year, we'll make another large effort to ensure that all of our records are 100% accurate to the best of our ability statewide. This includes our staff being more responsive to issues statewide to evaluate virtual options and ensure accurate records. Also, predicting the future of caseload volume and the mix of cases as we are at an unprecedented crossroads is more difficult than ever before. I anticipate that we will continue to see a low level of traffic enforcement at least through the end of this year, and maybe slowly increasing next year, but perhaps never making it back to pre-pandemic levels. I do anticipate an increase in criminal filings on our court to continue through next year, and these are probably our most labor-intensive cases given the jail and due process issues that they present, with the least amount of revenue due to the non-compliance and indigency factors in those cases. Finally, communicating with city stakeholders has become more difficult for several reasons, including difference of opinion on who is part of different discussions, what is appropriate discussions between the branches, lack of mutual understanding, efforts to influence or control processes, costs, and revenues. This has caused a lack of coordination on implementation of newer ordinances that impact our court. It used to be that the city spoke with a singular voice to our court through our prosecutor, who had over 10 years experience and understood our processes, but now we communicate with many different departments directly. And this has pluses and minuses, but we're working diligently to try to coordinate all these efforts that impact our court to understand what is happening from a policy perspective and give feedbacks on impacts to the justice system. The two most pressing legislative items from the last legislative session are contained on this slide. As of January of next year, our community must make a decision about the future of domestic violence cases in our court. We must either adopt an ordinance establishing specific protections and rights for victims, families, and witnesses of domestic violence charges, or remove domestic violence criminalization from the municipal code and defer to the state on these types of cases in the future. We are one of only about 5 or 6 municipalities in this state that handles domestic violence cases. And our system is set up to deal with these cases through our victim advocate services in the police department, our probation services through our court. Regardless, if we take no action as a community, the decision will be made for us. We will continue to handle domestic violence cases regardless of this, however, until we finish the cases that have already been filed with us, likely until 2025 from a budgeting perspective, to ensure that we can handle all of those cases appropriately. Effective September 1 of this year, all courts in Colorado are required to provide remote access to the public to observe any criminal court proceeding conducted in open court. This is a substantial mandate. However, there are exceptions for lack of available technology, private proceedings, safety concerns, and other reasons. We've been planning to comply since this has been discussed some time ago, as I really do look forward to the transparency to our community that this is going to provide. But as the deadline approaches, we do find ourselves struggling with staffing yet again, as we do have 4 positions currently inoperable for varying reasons. And with technology not working correctly, we may need to delay implementation on this in our court. But again, I honestly look forward to implementing this soon, within 90 days of our ability to comply being restored. Our team is up for these challenges. Our court staff is small but mighty. We've already introduced you to the other judges and KJ. But she, KJ, oversees a team of 10 total folks. Our deputy court administrator, Evan Venrick, who's been an outstanding addition, oversees a team of 6 specialists that focus on the day-to-day operations of cases that impact people's liberty and due process rights, and is extremely important work. I want to highlight some recent changes to our 3 programs. In an effort to reach our goals, particularly with rehabilitation and restoration, we've implemented these 3 great programs that we want to highlight tonight. I view all of these programs as extensions of the court itself and functions that fit the mission with great flexibility to meet our community needs. First is our continued restructuring of what we now call our community justice services under Christy Maestas. I think Christy is here tonight. Thank you for your service. Under her leadership, she's helped us to combine our formal supervised probationary functions that used to be a full-time role, but particularly with the DV case reduction, can now be part-time again. And with that, we've also combined pretrial services as well as a brand new process that has allowed additional monitoring and support for compliance prior to a scheduled hearing that has ultimately reduced appearances and saved money for taxpayers. These reduced appearances really do reduce costs for our specialists who are already overburdened with issues, as well as the city prosecution office, who also benefits from this service. She meets with defendants one-on-one after sentencing to ensure understanding of all requirements and answer questions, and also provides additional contact for early compliance and notifies our prosecutor. This process is a work in progress and still requires some additional coordination with the prosecutor's office to get on the same page, as this has created new issues. But overall, this really can allow us to be more efficient with those particularly who wish to comply early. We've also expanded, again, pretrial services as well as probation services, all falling under Christy's management there, like monitored sobriety, substance abuse counseling services, and domestic violence counseling. Next, we have our Court Navigator program. This program is a voluntary engagement for now, but may evolve at some point to a more formalized diversionary program in the future. The Court Navigator program's goal is to improve community and individual outcomes through increased voluntary cooperation. This helps clients achieve their goals, including their court obligations. The Court Navigator also works privately with the client to define the barriers that have made success difficult and develop a plan to achieve personal responsibility. This includes partnering with existing local agencies providing resources for rehabilitative services like mental health and substance abuse counseling, as well as other basic needs like housing, food, and employment resources. This program is a true asset to the community by enhancing public trust in our local justice system, increasing public safety, and ultimately saving money for taxpayers. Although the position has been recently vacant, I'm excited to announce that we have a talented individual coming on soon who's going to help us take this program to the next level. In 2021, just under a part-time program, the program served at least 42 individuals as a pilot project, and at the beginning of this year, January through May, we served at least 60 people. So this program has at this point served hundreds in our community, and we're working on better ways to report more detailed data through its multiple renditions just in the last couple of years. We've considered only a small minority served to be unsuccessful that have resulted in bench warrants for failure to appear or comply. Most all clients have been referred to housing, and many have been housed during their cases. Nearly half of the participants of the program were housed in 2021 alone, but with the federally funded vouchers drying up everywhere, I worry that we may not be as successful with some of our housing efforts as we were during COVID. Many have been provided a smartphone through connections with federal funding. Most were referred for mental health treatment, and most all clients have completed some form of community service since engaging with the program. The program also attempted to contact over 1,000 individuals with active bench warrants, and we've had over 75 individuals come in and resolve their case as a result of contact with the program. Most all clients have been qualified for Medicaid and food stamps, and only a few have needed assistance with re-enrollment or redeterminations. Now I'd like to introduce our Restorative Justice Program and give a big shout out to our amazing program manager, Ames Stinson. Ames, give a wave. Thank you for your service. They've done amazing community work to provide this, or really to prove this model here in Inglewood. I believe we enjoy the best municipal court restorative justice program in Colorado. This program creates a win-win-win for the community, the defendant, and the victim in a case through faster resolution and deeper healing for all involved. This program improves public safety by ensuring personal responsibility, rehabilitation of the parties, and restoration of the community on a case-by-case basis. The mission of the program is to foster resilience through restorative, collaborative, community, and system responses to crime and conflict. Restorative justice practices are victim-centered, community-based responses to crime or conflict which create that win-win-win opportunity for the harmed party, the responsible party, and the community as a whole. In facilitated conversations between the responsible party or defendant and an offender, between the responsible party or defendant or offender, harmed party or victim, and community, a contract is agreed upon by all to repair the harm created by the offense. In our program, we use a community group conferencing model, and the responsible party must successfully complete the requirements of that contract within the deadline, as well as not reoffend in order to successfully complete the case or be subject to traditional prosecution through our court. The program are victim-centered and focuses on the 5 R's, plus our local 6 that Ames has added, resilience. They can be utilized, these concepts, prior to formal criminal legal involvement at a variety of levels within the traditional legal system, but in our court, this really amounts to a diversionary opportunity for appropriate cases after a criminal justice filing with our court. Eligibility to participate includes requirement that the harmed party consent. If the harmed party does not consent, we will not accept it in the restorative justice program. Further, the responsible party must take immediate personal responsibility for their actions. If they do not, they cannot proceed through the restorative justice program. Further, the program currently handles the overwhelming majority of our juvenile docket, maybe 95% of juveniles at this point. We're also handling more adult cases, as long as it's not a domestic violence case or simply a traffic matter. We don't accept cases with active bench warrants. Finally, the prosecutor must approve, and the court must also approve in order to be eligible for the restorative justice program. In Colorado, 90% of offenders who participate in that program successfully complete their contracts, and 95% of participants are satisfied with the conference outcome. Offender recidivism rates are approximately 8 to 10%, substantially lower than in a traditional criminal case. Research also indicates that utilizing restorative justice can disrupt the school-to-prison pipeline as well as interrupt cyclical involvement in the criminal justice system. Our 2022 annual report showed very similar results in Inglewood for our first full year of the program in 2022 that we're very proud of. The hard work of our community has been fruitful, but the program, like the court, has seen a reduction in cases this year, not necessarily disproportionate with the caseload overall, but we do need to work with the police and the prosecutor to identify more ideal adult cases to ensure ideal caseload and efficiencies as we expand the capacity of the program with more volunteers. We now have over 50 trained volunteers and over 10 certified to actually lead groups. Please get involved and join us for an upcoming session. Feel free to reach out to Ames Stinson in the back of the room if you want to learn more as well. Finally, I want to give some ideas for the community to ponder and to discuss as we move our community forward on these challenges. These policy questions are generally outside of the scope of the court or the judge to answer. Asking each other if our cases and outcomes are generally aligned, or do we feel that they do not meet the community expectation, is a good question and conversation to have. Are there policy changes that need to be made? Understanding where those changes would be made. Are our efforts to protect public safety adequate in Inglewood? Are we handling our own issues where there is no state equivalent adequately? Like local zoning and sales tax issues? Is our ability to jail adequate for our community needs? We're fortunate here in Inglewood that we do not have bed space restrictions or general fund cost of jail in our cases like most municipalities in the state, but there is an obvious taxpayer expense and social cost of jail that should always be considered. Do we have adequate problem-solving programs in place to reduce recidivism in Inglewood and avoid the revolving door issues of ignoring the underlying mental health and substance abuse issues that have risen to epidemic levels here in Inglewood? Do we need to consider decriminalizing and implementing default procedures to any types of offenses? The state has moved that direction with civil infractions, and many cities have done so too. Some in an effort to free up more enforcement on more serious public safety issues in their community, and others to avoid jail issues altogether, as the public safety issues in their community are minimal. I provided some basic definitions of what decriminalization and default can mean. I'm not necessarily advocating for any of this and silent to policy decisions, but just trying to inform the system and community of potential impacts on the criminal justice system. But those are issues to consider that might be able to free up more resources for ultimately what's sort of contained in this slide, which is the crime rate slide provided by Inglewood Police Department. In Inglewood, we have no shortage of enforcement opportunities, but how to prioritize and try to impact this slide is the bigger policy question. I put this slide in not to alarm, but to illustrate that we have historically needed more police enforcement that some of our peers do not. With these new challenges that I just described, do we stay the course or do we make some changes to policy? I challenge you all in this room to help create a more defined plan on the future of enforcement and ultimately public safety. I'm not necessarily saying we need to file more cases, but we need to have a plan not to ignore criminal activity in our community, as well as not to ignore human suffering in our community. Finally, I'll leave by highlighting that our court can play a major role in reducing recidivism and protecting public safety through the programs I just described. We can help rehabilitate and restore the community on a case-by-case basis as we gain efficiencies in our problem-solving efforts together. Through these efforts, we can make Inglewood the best it can be. You know, at this time, I just want to thank everybody in the room for their contributions to our community. I think it's your individual contributions as a resident, as a business owner, as a leader, as an elected official, that really creates that small town feel of Inglewood and makes us different from others. Our court has engaged Inglewood's core values through our efforts to make Inglewood safer, as well as the best place to live and do business. Thank you for the opportunity to share tonight. God bless you all, God bless Inglewood Municipal Court. I invite you all to head back out in the lobby and enjoy some more refreshments and networking with your peers. I'll be out there to answer some questions as well. Thank you all.